a known mafia king against whom there was a murder trial pending for publicly gunning down people continued in office. I read the Nabam Rabia judgment not as laying down an absence of power, but as laying down a code of conduct. Or rampant corruption in election also continue in office. That's one of the banes of our system till such time as a election tribunal declares them to be wrongly elected. And then we come to 190, which is houses of the state of legislature. So we are really concerned with 190 because we are talking about state. Issues. And 190 sub-article 2 tells your lordships, no person shall be a member of two or more specified, then after the expiration of the period, etc. We are not concerned because we are really concerned with sub-article 3. A becomes subject to any of the disqualifications in 1 or 2 of 19 of 191. So we may not go to 191. 191 applies to at both stages for being chosen and for being a member. A, C are post occurrence of events. Unsound mind and stand so declared by competent court. A pendency of a petition in a court to declare somebody incompetent is not good enough. Pending insolvency is not good enough. Look at E now. If he is not so disqualified by or under any law made by Parliament. Now, today, your lordship was told eloquently of how terrible it is to allow those hit by 10th schedule to continue. But it is not every time that there is corruption because of which there is defection. There may be times where people may defy a whip. There may be time when there may be a split in a political party. Now that sub-article 3 has gone, you have a problem. And people may say, we will brave disqualification, but this chief minister has to go. But look at, my lord, the Representation of People Act. You may have a person who's elected in which there are allegations of booth capturing, of violence. I remember, my lord, once somebody was arguing the case for one of the persons from Bihar, my lord, who was in jail and saying he should be allowed to come. Mr. Tulsi was arguing and he told Justice Nanavati, he said, see the majority by which my client has won the election. And Justice Nanavati said, if your client had his way, he would have had no opponent. He would have killed all of them. So, those kind of cases are pending. A person, a known mafia king against whom there was a murder trial pending for publicly gunning down people continued in office. Where does it? My lord, we have cases, and your lordships have dealt with these cases in the High Court and sometimes in appeal in this court. You have cases of the worst kind of electoral offences pending for trial. What happens to those people? They continue in office. So, my lord, there is nothing so shocking that in our system, many times people continue in office where there are serious allegations pending against them. That's the bane of our system.
Thank you.
Thank you. Thank you. Now, with that, my lord, see the language of 191(2). A person shall be disqualified for being a member if he is so disqualified under the 10th schedule. So that disqualification must take place. And that disqualification in the 10th schedule does not take place until there is a decision of the chairman or the speaker under paragraph 6. Any other view, my lord, would be equally or would be far more disastrous, because today all you have to do then paralyze the working of an assembly is to file disqualification petitions.
Mr. Salve,
Yes.
till here there is no problem.
Yes.
The position under the Constitution is very clear.
Yes.
And also the judgments of this court.
Correct.
Concluded with this expression, the decision.
Yes.
The problem arises the time, context, and the stage at which speakers choose to take a decision.
Yep. I was going to straight away address, but yeah.
I mean, in that,
Yes.
is in that context that
Yes.
either that he shows over anxiety to immediately decide violating principles of natural justice, or he just doesn't decide for times to come.
So, the short answer,
pending 10th schedule proceedings,
yes.
the powers to be exercised either by the governor or the political process, as it were, goes on,
Yes.
makes the application redundant many a time.
May I not respectfully answer? This has been the biggest problem of appointing a speaker. Mr. Sibbal was right when he said, your lordships express hope and faith that the institution of the speaker will rise above politics when it comes to the 10th schedule. Our experience may not have fully risen up to those expectations. But that's where we have to drop that. The point, my lord, is this. Not the respectfully answering Justice Narasimha's question. If your lordship has seen, the rules here have in one sense a constitutional status, because the rules are framed as a delegate under paragraph 8. And those rules can and should provide a time frame in which these petitions have to be decided, both giving fair opportunity. So these rules normally say you will give so much time for giving a reply. One of the reasons why our group came to court is even that time was not given. And equally, perhaps its time has come for the rules to say, if a petition is filed, he shall, unless there are compelling reasons to the contrary, dispose it off in 90 days or 60 days or something like that. And there, my lord, then judicial review will come in. If a speaker is dragging his feet and the rules say he must decide it absent compelling reasons within a given frame of time, judicial review will come in. You can go to a high court and say, issue a writ of mandamus directing him to dispose of, because then you will have a legal right to ask for a decision within a given time. So, my lord, these are the only ways in which your lordships can address these lacuna. Now, what is the relating back? Relating back has two dimensions. The event has taken place. So, ultimately, the subsequent events will not affect, it will not efface the wrong which you've committed, the political wrong which you've committed, which disqualifies you. It's over. My lord, if you enter into an office of profit, you're disqualified. If you resign 3 months later from that office of profit, it is not saved. You're disqualified on that day. So, my lord, that disqualification is based on a set of events. But please consider the consequences, which will be contrary to the terms of the Constitution, which says no act of the House shall be declared invalid merely because a member participated who was not entitled to. Now, first of all, here you are entitled to participate, but even if a wrong person comes in, you cannot go annulling the work being done. Today, my lord, if when the defection petitions are decided, if some of them are allowed, in between laws have been made, resolutions have been passed by the House, all of them can't be revisited. So, my lord, that's the respectful answer to the ex post facto point. That as a matter of law, and my lord, I read, since your lordships have kept this question back,
What were you saying, Mr. Salve, as a matter of law?
as a matter of law, my lord, I read the Nabam Rabia judgment not as laying down an absence of power, but as laying down a code of conduct. Let me explain what I mean, my lord. The speaker is
The Mr. Salve, in a sentence, can you just summarize your ex post facto on ex
Yes.
post facto? What is your, so we just,
Right.
if we
Yes.
formulate it, we can take it down
Yes.
there.
My formulation of ex post facto is as follows, my lord. The disqualification will have to be decided on the basis of the acts and omissions of the allegedly delinquent member on that date. But subsequent events will not cure that. If on that date you defied a party whip which was lawfully issued, that's the end of the matter. The fact that the party collapsed thereafter is neither here nor there. If it is pursued
Yes.
to its logical end, that wrong has been committed. And I give, my lord, the example of somebody who takes an office of profit. Let's
But
get into
You
non-controversial.
can just continue to sort of complete the formulation. I got that the
Answer.
disqualification will have to be decided on the basis of the acts and of omissions of the allegedly delinquent member on that date.
When he committed
Subsequent
those
events
acts,
will not cure that.
will
What
not
the
efface,
call also said.
will not efface.
What is the sequitur?
Yes.
What is the
But the
sequitur? How do you?
sequitur is, however, until the date of decision.
Yes.
The person is entitled to participate. And Article 189 subarticle 2 makes it clear that his acts, his functioning in the house in the interregnum does not vitiate any actions of the house. If this is so, my lord, we have no problem in reconciling to the fact that people with the most serious allegations of having been elected by wrongful means such as booth capturing, threatening witnesses, or rampant corruption in election also continue in office. That's one of the banes of our system till such time as a election tribunal declares them to be wrongly disqualified. That's the way it is. So, my lord, my respectful submission is that yes, the rule should be amended, decision making should be made time bound, judicial review will be available where a speaker is holding back. All those are ways which we can fix this. But, my lord, the legal consequence of the pendency of these proceedings and its ultimate decision, this is the principle of ex post facto which must apply.